Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Recording live from FYP Studios East and West, transmitting across the internet, this is episode 90 of Registry Matters. And Ashley is joining us from Liberty and Justice MF Coalition. What is the MF?
Mother's Finest.
Mother's Finest. I like it. I like it. I like it. Is Rick going to approve of that moniker?
Not sure. We'll have to ask.
I have a question, and feel free, either of you, to chime in. It was torrential rain, but my question isn't about the weather. Why, when it is raining to the point that you can't see 10 feet in front of your car, do people still drive without their headlights on? You can't see, and they're driving in a gray car. You can't see them. Why?
Because they like to live dangerously.
I mean, this is asinine.
I can explain it very easily.
Please, enlighten us.
Okay, well, what happens if you've ever lived in a climate where rain comes and goes? It could be that they have been driving before it started raining, and they don't know that their lights are not on because they didn't need them at the time they started. It's kind of like when you're driving when the sun goes down and you don't have automatic lights. So the older vehicles that don't have the automatic light, of course, you have to also set it to automatic. But people don't realize they're driving without their lights. And I had that discussion with my brother about a year ago when he was cussing somebody to the top of his lungs about not having the lights on. And I said, well, are you telling me that you have never driven without your lights? He said, absolutely not. I said, really? You've got a perfect memory of every single time you've been in the car, and you know exactly when the sun has fallen below the horizon, and you know that you have never forgotten to turn your lights on. I said, you're a miraculous person that you have that type of memory. So I suspect that people got caught in downpours and didn't realize that their lights were not on, would be my guess. I don't think anybody deliberately wants to be hit by another vehicle or to be driving unsafely.
Ashley, I knew that I was going to poke the bear and get Larry to go off on a rant.
You did. You totally poked the bear.
Well,
Larry,
I just assume that people. My brother will say he pulled out in front because he wanted me to hit him. I say no, he did not want you to hit him.
That's probably not true.
He did not see you. Yeah, it's like. So.
Generally speaking, I don't think that people get in their cars wishing to get their head smashed in.
Generally speaking.
You have joined us before, Ashley. Larry, would you do the quick 30-second intro?
Ashley is the staff attorney for Liberty and Justice Coalition, which is the New Mexico state affiliate for NARSO, the National Association for Rational Sexual Offense Laws. And Ashley has been a prosecutor for most of her 25-year legal career, but she's done other things. But she's prosecuted every type of crime that there is, from murder to arson to DWI to domestic violence, and she's now working as a defense attorney, and she's also working as our staff attorney for Liberty and Justice. So she has been with us before, and I'm hoping that she'll be with us on a regular basis.
Outstanding. And as I recall that, Ashley, you are at least minimally charismatic, and you're significantly more than that. You're very fun to have on the podcast, and you're welcome anytime.
Aw, thank you.
I like spunky, funny replies and being able to keep up with being somewhat snarky.
That I can do. I can always keep up with snarkiness.
I do want to kick out a quick reminder that any of the people that are doing the Patreon side of things, that you do have a little bonus episode over there on the website if you're not downloading it on your podcast. And that is also a little backhanded plug. If you're not a Patreon supporter, then you're missing out on some bonus episodes that we've started releasing, maybe one-ish or so a month. And there's an extra 45-minute episode that we did last week when we had the 3 different decisions that we talked about. So if you want to get that, telling you $1 a month feels to me like a massively good value for you if you want to get deep dives into these different subjects that we go into.
It's
probably the best bargain out there.
I'm telling you. Thank you for that. That's great.
It certainly sounds like a good buy to me, because if you get the podcast for free and then you get a deep dive for no more, you can go as little as $1 a month. That's $12 a year.
Seems like a good value. I mean, we even have like Will in chat who does that at that level. Not to call you out, Will, and he gets the bonuses and he loves it, right? All right.
Well,
So
and we're really trying to jack our patron numbers because it makes us look good to have a larger number of people that are subscribing or at some level to the podcast. So we'd like to see that number. He says
absolutely in chat that it's worth the value.
Yeah, so we'd like to see that number double. And I said by the end of the year, but we're going to have to really push to make it double by the end of the year.
Yes. All right, well, let's get going, and here we go. All right, Larry, tell us what's going on for the breaking news.
Well, this is an old story, but it has a new twist to it. This is a civil commitment as it applies to sexual offenders, which happens in 20 of our U.S. states. This is a case of a young man, relatively young man, but of course by my standards, anything's young, named Galen Baughman, and he's facing a second civil commitment trial in the state of Virginia beginning on Monday, and we plan to do a deep dive. But the breaking news is that the Commonwealth has decided to seek commitment on him for the second time after they lost the first time some number of years ago.
And they have the authority to do this. What?
Well, we don't know that they do.
But I'm trying to not jump too far ahead. Do they have? Is this a case of they're doing it until they're told to stop?
That is correctly. That is prozactly. I love my word prozactly. That is prozactly what they're doing. The civil commitment statute is silent. It doesn't say that they can only file one. And if you're a textualist, you would believe that if they had only wanted the prosecution to be able to file just one petition, they would have said so. And so until we get some case law that says that they can't file a second petition without what's called a predicate offense, which is one of the offenses that makes the person eligible for civil commitment to be sought, they'll potentially file a whole lot of these if they are successful in this one. So this is a very, very important case. It affects a small number of the offender population. It's in the, I think, 3,000 or 4,000 across the country, but 3,000 or 4,000 is a lot if one of them happens to be you or your loved one.
And I think in the interest of time, I think Ashley is just going to stick around pretty much just up till the top of the hour, and we're going to dive right into this one already. Do you guys want to just start going at it, or how do you want to proceed from here?
Well, I would be delighted to go at it now, and we'll do the articles later. But this is something where NARSAL has issued a statement a year ago about this particular case. We've issued a statement many years ago about civil commitment generally as it applies to sex offenders, and we need to probably do a little bit a deep dive explaining that all states civilly commit people, but this is a different and unique process for the 20 states that have this separate track for sexual offender civil commitment, and this is a scary form of civil commitment compared to what is generally accepted as civil commitment, which all states have some level of civil commitment that takes place. So, Ashley, have you ever done civil? The DA's offices do those in New Mexico. Have you ever done a civil commitment?
Yes, I have, but not on sex offenders, and I definitely have not done one in the way that they're doing it.
Well,
let's think about this.
We don't have that kind of commitment here. We don't have that kind of commitment here. So I would hope you haven't done one.
No, even the dangerousness hearings I've conducted they don't even rise to this level, because let's think about this. I can't even imagine any other type of process that you get 2 bites at the apple on. You don't get it on trials. You don't get it on a whole bunch of other things. If you can't civilly commit somebody the first time, you don't get to do it again and then take away a bunch of the tools that person might defend themselves with, which is exactly what we have here.
Well, and can you elaborate on that? What are some of the tools that they've taken away from Mr. Baughman that would normally be? I agree with you completely. That's been my point in the writing I've done about this particular case of civil commitment, is that this is a second bite at the apple without an additional predicate offense. We would probably be willing to concede, although we wouldn't like it, because I don't agree with the whole process to begin with. I think that if they have a mental disorder, they should be put in the mental health system, not in prison. But if you're going to have civil commitment and it's not unconstitutional, if they were to commit another predicate offense, I think we would agree that that you could file another petition, right?
Right.
But that's not.
I think we would have less problem with that.
But that's not what happened here. He texted if the allegations are assumed true, which we will for this conversation, he texted a 16-year-old with what was nothing criminal about it, except it was a violation of his probation. He texted a 16-year-old, and there was nothing they could prosecute him for, but they revoked his probation and fined him out on probation. And then 30 days before his prison incarceration ended, then they filed this petition. And they have no new criminal offense. They're trying to commit the man for the same behavior that constituted the predicate offense all these years ago.
Right. And I think you've put it plainly, and at least one of the things that I've read from last year is that I don't even want to say thinly veiled. This is a flat out attempt to extend a sentence for somebody that is already going to be done with their sentence, if not already done by the time they do these civil commitments. So essentially they're doing what the law says they really can't do, which is once somebody is done with their time, you can't then increase their time unless they commit something else, and then you have a whole new crime. But that's not even what happened here. These weren't even texts that were sexual in nature. Let's assuming that those facts are true, like you said. And essentially what they're doing is they are going after him again because they weren't able to civilly commit him in 2012. So now they're initiating the process again, except this time they're not allowing him to talk about any of the exams that he had done and the ones that even the state had done that said that he isn't dangerous. I've never even seen a process like this.
So the state, the process that would send him to a facility for examination, if I understand it correctly, that examiner said that he didn't qualify in the select category, and they still went out and hired a separate evaluator to get they went opinion shopping. Isn't that what they did, according to what we're reading?
Not only did they do that, but I believe by statute that they aren't even allowed to do that. And instead, they went ahead and went outside who their accepted practitioners were to do these type of exams, went off the grid, so to speak, found one that would say exactly what they wanted to, and then the judge is not allowing any of the other stuff that you would rely on to conduct those initial examinations. He's not letting any of that information come in.
So they get a second bite at the apple. So they get to talk about his offense that a previous jury has already heard about. They get to go back and talk about that offense again, and he doesn't get to raise in response to that in rebuttal. I mean, we all understand what rebuttal is. So he doesn't get to rebut that and say, yes, I did commit this heinous offense, if you want to call it heinous, although it wasn't very heinous from all accounts. I committed this heinous offense. And you people tried to commit me already. You people failed, and now you're at it again. He doesn't get to say that, right?
Right. He doesn't get to say that they did not find it in 2012. He doesn't get to talk about the exams that have been conducted on behalf of the state, no less, that state that he is not a danger and is not in need of this additional civil commitment for mental treatment. He's basically being hand-tied in a trial that the state holds all the cards, and he has nothing to put up against that.
Why? Why can't he present that stuff that says that he's not a threat?
The judge has ordered that is not allowed to come in.
But at the same time, then the prosecution can bring up all the bad stuff?
Yep, that's exactly what we have going on here.
I'm just going to ask the dumb question. That sounds unfair. Right?
It's completely unfair, and I honestly have never seen, even in some of the jurisdictions that we have here, I've never seen a judge do it this blatantly.
Does this then, do you think that this would then, let's say they take him to court and let's say they civilly commit him, does that then start rising something to a threshold to bring a SCOTUS, to elevate something to a SCOTUS challenge of this being, permanent imprisonment without any sort of due process?
Oh, absolutely. There's going to be a definite due process claim as a result of this. Unless the trial plays out differently than what we're seeing right now, it's going to, I don't want to say automatic appeal, but there's definitely a due process violation claim that can be raised here.
Does this mean that all of the advocacy, the ACLUs of the United States, will they step up and throw their hats in?
Now that I have no idea. I don't know how much interest they have in the civil commitment area. Larry, maybe you know?
Well, I'm not quite as optimistic as you are because I see this. There will certainly be an appeal if they commit him. This man, fortunately, is connected with enough resources, enough people like him, enough people recognize there's going to be an appeal, and I can almost speak for NARSL that we would want to be supportive of any way we can. But the issue here, this appeal will not be to bring down civil commitment. This appeal will be that the decisions that are being made that are suppressing the evidence by the judge that are violating his due process rights. That's what the nature of the appeal will be. Civil commitment has been upheld time and time again.
Sure.
Right.
So,
right.
And why don't we just actually, since we've got a person who's licensed to practice law, why don't we get into something that I try to dice out as best I can, and people roll their eyes. For something to be facially unconstitutional, that means that there are no set of circumstances by which that particular practice could be constitutional. Civil commitment,
correct,
is constitutional, right? Civil commitment in and of itself, not sex offender commitment, but simply the act of civilly committing someone, that is constitutional. I'm presuming since all states do it, right?
That has been upheld over and over again, as you pointed out, that you can civilly commit somebody. However, there is a threshold and there is a process.
And so what we have to challenge with sex offender specific civil commitment is if the process is robust enough to meet the process that we have that protects people in regular civil commitment. If we just simply say civil commitment was unconstitutional, the courts will look at us, they will roll their eyes in disgust and say, how can you come before us and make a claim like this when clearly civil commitment is not facially unconstitutional? Your particular claim against your particular state and your particular circumstances as applied may be unconstitutional, but the mere act of civilly committing someone is not unconstitutional. So therefore, we're never going to bring down civil commitment across the board because it's eminently constitutional if it's done correctly.
Which would take us to the due process side of it, that this is not happening for Galen.
It's certainly not happening for Galen. And it doesn't happen for a whole lot of folks because what happens is they get to the end of their prison sentence. They have no money. They've been locked up for all these years. And the state files this petition where unless the statute of the state provides them indigent funds, they don't have the right to counsel because they're not facing a criminal charge. They're facing a civil proceeding. So they're facing the power of the state, the vast power of the state, with no professional resources, no money for experts, and no way to rebut this very low presumption that as you have to have a mental abnormality, and it's such a low standard that it's very easy to commit these people. If you take a person who has nothing to fight with, no resources, and you have a very low standard, what do you suppose is going to happen when you file a petition against them?
Yeah, you're screwed.
They're going to lose.
And that's what's happening. There's of these 4,000 or however many it is, I hope some of the listeners that we have in civil commitment will give us some solid numbers so we can go back next week and say how many it really is. But of the several thousand people in civil commitment, very few of them got anything that resembles due process.
Where's the breakdown for this in the due process, arena? I mean, shouldn't there be someone that's going, hey, this is violating this dude's due process? Shouldn't somebody along the way be saying this? Like, I don't know, the judge?
So I'm guessing that the defense attorneys have already raised and preserved these objections for the appeal. But yes, judges are supposed to uphold the due process and constitutional rights for whatever reason and cannot comment on what the motivation is or anything else without knowing additional factors. But essentially in this one, it's setting it up for a good due process appeal.
Can I ask, is it because he is to some degree connected? Is it because he's the guy that was doing TED Talks, right, Larry?
Yes.
Okay. So is it because he was out there, made some kind of mockery of them letting him go, and now this is their retaliation? Something like that?
It very well could be. The system, they're sore losers. They are very sore losers. You know, I grew up believing that when the court said something, the court decreed something, the court ordered something. I believe the people put their hands on those Bibles that said, I believe that they would actually fall into line and follow those orders. They don't fall into line, and they don't follow those orders, and they have nothing but contempt for those orders, and they do everything they can to retaliate. So it would be a possibility. And also the possibility has been raised. I haven't seen enough evidence to convince me of it, but the possibility is because they're being extra zealous because he's gay. That has been leveled as an allegation.
So go ahead, Ashley, please.
Because Larry brought up a really good point about it could be potentially because he's gay, because when we look at the factors that they're considering for the civil commitment, there's it's like 450 pages of stuff, and I could be totally exaggerating the number of pages, but it's skewed heavily so that if you're young, because of some of the questions that automatically add points. So for example, if you're 19 and you commit your crime and you haven't been in any other relationship other than the one with the victim, it bumps up the points. If you're gay, it bumps up the points because it falls under that same thing. So it is skewed in terms of not being fair if you fall under a couple of categories.
Doesn't that violate like some 14th equal protection stuff to even ask that question?
And I was actually considering that when I was reading through the criteria that they were using, that there might be an equal protection argument here. Larry?
Well, if we have, I mean, the static 99 is the instrument I think that they went to in the Commonwealth. That is biased because it does elevate the points for homosexual behavior. I don't know if it does or not. I mean, if there is, you guys are great on your figures or your statistics, and you say there should be empirical evidence. If there is empirical evidence that supports that, not that I'm saying I'm for it, we're having a discussion about whether they can do it constitutionally. I don't know that there is a constitutional claim if there is empirical evidence, but again, this is not me saying I endorse it. The question was whether they can do it from a constitutional perspective.
Well, I see this as similar to when the schools were being challenged on the testing that was skewed in favor of, not skewed in favor of minorities and basically were detrimental in certain city areas. I see this as very similar. If you have a test that's static 99 and it asks questions and it gives you points, and no matter what you do, if you're in a certain criteria, for example, if you're gay and you answer those, you're automatically getting points, whereas somebody else might not be in that situation. I think it can rise to an equal protection argument.
Isn't the static 99, doesn't the 99 represent the year that it was enacted?
Could be.
Or am I reading into that too much?
I don't actually know what that means.
All right, well, let's just hypothesize that the static 99 has been around for a while, like prior to the social acceptance level that homosexuality and same-sex partners are in the United States at this point. That could be information that was presented at a time where there were still sodomy laws, or they hadn't been all the way removed and all that, and you still had massive bias. You still have bias, but like more biaser, as it were. I don't know how people have same-sex relationships and they're quote unquote perfectly healthy. And I say that with the quotes just to say that it's kind of a stupid thing to even bring up that they're perfectly healthy, because it's kind of sort of normal at least societally at this point. We covered something, Larry, about a year ago, where they were giving a guy cane lashings for being gay. We're not doing that in the United States, at least.
Sounds like a pretty good idea, actually.
This is really troubling. Can I ask a question from chat real quick?
Sure.
All right. Will asks, how can someone be found totally sane to bear the full punishment for their crimes on the front end at trial, and then on the back end they're magically incompetent to be released upon expiration of their sentence?
That is an excellent question. And the question that follows up on that is, how can you be deemed mentally fit or competent to stand trial, but you're mentally unfit or incompetent to release? It's the same thing.
Well,
and therein lies the nuance. Go.
Therein lies the nuance. They don't mask this. They don't pretend like you have something that's in the DSM-5. I believe that's the volume. They use the term mental abnormality. They don't say mental disease or defect, and the mental abnormality that makes the person predisposed to have urges or some kind of vague language like that, and it varies from state to state of the 20 states that have them, but they center greatly on mental abnormality because they know that they're playing a game here. If the person was mentally defective, they never should have gone to prison because we're supposed to treat a person as incompetent. Or now this is where I have a lot of. We're going to take a detour here on incompetence versus insanity. There are two different legal thresholds for being incompetent to proceed and being being irresponsible, being not held responsible because of being legally insane. There are two completely different standards, and lawyers I get into arguments all the time, and they'll say they're one and the same. No, they're not one and the same. The first one has to occur to determine if you are fit to proceed. And that's a very low threshold to determine if you understand who your defense attorney is, what role they play, if you're oriented to person, place, and time, if you can participate with your attorney and assist. It's a pretty low threshold to be incompetent to stand trial. And then whether you are not responsible for your criminal behavior, it's a different standard, and it varies from state to state a little bit. But it's basically whether you can understand and appreciate the criminality of your actions, which the examiner always finds you can understand that what you're doing is unlawful. And then if you do have the ability to understand it, are you so diseased or defective that you can't conform your conduct to the requirements of law? And that kind of gets to the old irresistible impulse McNaughton test that used to apply. Those are two different sets of facts that deal with mental health, and incompetency is not the same as insanity. So you lawyers out there listening, try to understand the difference.
And there is a difference. You're absolutely right. I mean, you succinctly, do you know right from wrong in order to have not committed the crime is completely different on whether you're competent to stand trial. Those are two different things. But essentially, they're trying to do that in the civil commitments. They're saying, okay, you're competent, but you can't be released. And back to when they were in prison or even on probation, if they were so mentally unfit for release, why didn't they start getting them treatment there? Why wait until after the sentence is over unless you're actually just trying to increase the sentence without statutorily increasing a sentence?
That is what this civil commitment is nothing more than a very expensive, and they pay gobs of money because even in the states where they try to provide treatment, like that's where they spend, where they put on the dog and pony show trying to provide treatment, they spend gobs of money for this civil commitment, but they're still intending on keeping the people locked up. Minnesota, for example, I think very few, if any, have gotten out of that facility. In fact, they're expanding it because a federal judge declared it unconstitutional. And the Eighth Circuit overturned the federal judge and said it's quite constitutional that no one has the right to get out. Just because people are not getting out, that doesn't mean that they couldn't get out someday. So they spend a ton of money on this. This is a livelihood for a lot of folks who make their living on keeping these people committed. And the examinations that take place through these kangaroo courts that they do, this is big business.
How is this not double jeopardy, Larry?
It's not double jeopardy because it is a civil commitment, and it's not a criminal prosecution. It's regulatory, and it's for the good of the person. So if they were charging them with a new crime, it would be double jeopardy if they were charging them with the same crime again. But they're merely coming in and saying, well, we understand that you've paid your debt to society, but you're not quite ready for release, so we're going to try to put you in a facility where you can get some more help. And this is not to punish you. This is merely to get you the help you need.
Wow. All right. I'm deeply confused. And Will again posts, he says, it's a cheesy end run around double jeopardy is what he's saying.
That is precisely what it is. This is a game that's being played, and it's a sad commentary on our society that we're allowing this game to be played. We wouldn't allow it if it weren't for the despised population that we have labeled as sexual offenders. We don't allow this type of thing to take place with regular civil commitment. The whole goal of civil commitment, when someone goes on top of a water tower and they start screaming all kind of obscenities and spray painting the side of the thing and threatening to jump, when they take them to a mental health facility, the whole goal is to release them. Of course, if you do too much graffiti, they may charge you for the vandalism on the side of the tower. But the goal of that, when Ashley was doing that prosecution, not prosecution is probably not that when she was doing that civil commitment proceeding, she was not salivating saying, I'm going to make this person suffer. She was salivating saying, I hope we can get this person some help. Right?
Right. Absolutely. I mean, that's the whole goal of the civil commitment. And even when we do the dangerousness hearings here, which are a little bit different but have a pretty high threshold, it's to treat them back to competency under that, and even the civil commitments to get them treatment. It should never be about punishment. In fact, that's the whole reason the Supreme Court keeps saying, oh, it's not punitive because the purpose of the detention is psychiatric treatment. How can you have that purpose if you're not even sending them off to get treatment?
So,
right.
But when we commit a person to our state psychiatric center in Las Vegas, New Mexico, the minute you walk in there, when the first clinician does their intake, they're trying to figure out how to get you out of that facility because it's very expensive and society doesn't want people there. It's their liberty is being restrained. So when they can get them stabilized on medications and hooked up with community resources, the goal is to get those people out. That type of civil commitment, if that was what this was really about, would be a lot less objectionable. But that's not what this is all about. This is not about to get those people out. You even take, I think we've talked about John Hinckley a number of times on this podcast, when he was found not guilty by reason of insanity, and I believe that was in 82, the shooting happened in 81, but when he was found not guilty by insanity, of course, after shooting the president and the press secretary and 3 law enforcement officials, that person's going to be perceived to be quite dangerous. But the goal of his confinement, which was civil because he was found not guilty, was to release him someday, and he was released. He has been released. And he's free to go on with his life.
Very strange. This is really, really disturbing and really terrible.
It is. And let's not forget that. So what they're doing is these civil commitments under Sexually Violent Predators Act, the SVPA. But in fact, in Galen's case, his predicate offenses were actually not violent. The victims didn't even want to testify. So we're essentially punishing him for things that shouldn't even fall under this act.
Alrighty then.
Well, we're going to be following this very closely. NARSL will have a representative in the courtroom at least one of the days. They've allocated 5 days for this hearing. We're going to have someone there at least one day or maybe more to observe and try to make connections with his legal team and let them know that we find this very, very troubling and we want to be supportive. Whether or not you like Galen is irrelevant. This is nothing about this doesn't resemble anything that America should stand for in terms of due process and fundamental fairness.
I have one other final question I have to ask. If the left is quote unquote, if they are willing to throw the Constitution out the window, blah, 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 and the right stands for Constitution and due process and all that, shouldn't they be like burning down the place trying to get this to have the due process side of it?
Well, who says that? Where do you get those assignments of who's for due process and who's not?
I don't know. I'm just making up, trying to stoke flames, and people claim this, that, the other thing. And anyway, shouldn't all of the people that believe the Constitution stands for something, like judges, shouldn't they be just chomping at the bit to go that this is incredibly terrible, regardless of what the case is?
Well, Ashley, I think that the judge is essentially a neutral referee. Doesn't an objection have to be raised before a judge can rule on it, or can they rule sua sponte on a motion that hasn't been made? I mean, I'm assuming he's got a very fine legal team. They're going to be making these objections, but can the judge himself object to the way this is proceeding, particularly since this judge is making the horrible rulings that are on motion of the state? What gives here? Who guards the hen house?
So, yes, judges are supposed to uphold the Constitution.
what I thought.
They're the judicial branch that does that. So sua sponte, and I have seen this all the time, that if they feel somebody's rights are being violated, then they're supposed to do something about it. Now, technically, should there be motions? And I'm sure there have been motions from the defense, but they're still the guardians. They're the final guardian, because before it ever gets to a jury or anybody else, they're the gatekeeper that ensures that no due process is violated prior to that.
So,
why do we start the podcast off with shitty news?
Well, I hope that we can spend more time on this issue, this very important issue of civil commitment. And for those who listen to us in civil commitment, we don't talk enough about this issue, and we're going to try to do better.
Very good. Ashley, do we need to let you go?
Do we want to talk about the New York law before I go?
That sounds good to me. We can bump that up to the front layer if you're okay with that.
Sure, because I'm going to let her drive the bus.
Ashley, what is this New York law thing you're talking about?
So there is a New York law, and if I'm reading this correctly, it is 2836C, which is the 2019-2020 regular session in the Senate. And essentially what they're enacting is, it's a variation of the Tennessee law about not residing with children that are victims of crimes. This one, however, does not take it to the level that Tennessee does. What they're actually stating is that they're finding it dangerous for the child to be placed in custody or have unsupervised visits with a person who has been convicted of several enumerated sex crimes, including first-degree or second-degree rape, course of sexual conduct against a child in the first degree, and then a couple of other offenses. Or if they were actually the victim that the person was convicted of, then what they're stating is that the offender can't have the child back as custody or have unsupervised visits with it. It is way more limited than the one that we're seeing in Tennessee. I don't want to say it's of concern so much as it is that what it seems like they're doing is to make sure that they're just trying to protect children because they're doing it under the domestic act that's in the state. Larry, do you have a different take on it?
For what little I was able to determine, I see it as far more limited, but I don't know that I've fully dissected and digested where the limitations are. I'm always concerned because the family courts already have the prerogative to do this. So I always view these with great skepticism because I believe it's a solution in search of a problem, and I believe this is catered to the victim industrial complex.
I'm pretty sure you've coined that term, Larry.
I think he has.
Already the courts have ample power to remove a child from a parent or a guardian that's unfit, right, Ashley?
So essentially what they did in this one, and they have that ample power. However, what they're doing, it says down at the bottom of this act that they're applying it to the Family Court Act. So all they're doing is expanding on the Family Court Act and stating that if you have two parents and one of them is convicted of molesting the child in that custody situation, that the person who's convicted of that cannot get the child back.
So it has to be that particular child.
Yes, on that, or the enumerated giving custody or unsupervised visits with a convicted sex offender if it was one of those enumerated things. So essentially we're right back to the Family Court Act, just limiting.
But wouldn't, if you were convicted of one of those enumerated sex offenses, wouldn't that preclude you from having relations with your own child if that child wasn't convicted, if it wasn't the victim, if it's one of the enumerated offenses? Have I got that right or wrong?
That is what they're stating. They're stating custody or have unsupervised visits. So yes.
Well, wouldn't that essentially block that parent from having custody of and visits with a minor child, even though that person wasn't a victim? Like I say, I haven't fully digested this, so I'm still struggling with it.
So the way that I'm understanding the language is actually that, let me see, notwithstanding any other provisions, there was language who is subject of the proceeding. Oh, was conceived as a result of. Actually, they do. So
okay,
it is.
Okay.
They're making it very narrow.
Okay.
So So as I read it and understood it, and they used legalese in there to me at least, if you perform one of these acts on your child, you can't gain custody or unsupervised access to your kid later, correct?
Correct. Or if they were conceived as a result of the rape of the mother or some of the other sexual assaults that are enumerated in here. So it is very narrowly tailored to that, not just if you have a child and you're convicted of a sex offense.
And feel free to throw all of the darts at me. Is this bad?
Well,
let me ask it this way.
Ask a lawyer.
Let me ask it this way then.
Something is good or bad.
Yeah, let me ask it this way then. If it feels like that would be in the interest of the child. So the more broad question is, what are the hidden areas that I'm not seeing right there on the face of it that would come back and do something, unintended consequences later, I guess? Like if it was a non-familial child under the age of 12.
And that's not actually in here. These are just the children as part of the union or as that are conceived as it. But there's always going to be hidden landmines as far as I'm concerned, but at least they very narrowly tailored this. I guess one of the concerns to me would be if you didn't want the other person to get custody of the child. We already see incidences where there's allegations of abuse, sexual abuse against the other parent. And to me, this could perpetuate that.
Larry, do you see any hidden trapdoors there?
Not having been able to dive deep enough into it, my general thing is I always fear trapdoors, anything the victim industrial complex is behind, because they don't analyze things from the same perspective we do. They analyze it from it sounds good. Like they say, terminate the parental rights of a rapist. Well, that sounds really, really good. If you went out and asked 100 people on the street, should we terminate the parental rights of a rapist? 100 people would say yes. But when you peer below the surface and you look at what constitutes rape, well, there's all these variations and degrees of that full universe. So in our case, when the victims advocates industrial complex, they bring that legislation in, they include the entire universe of sexual offenses where in cases where people have gotten together and stayed together and they've conceived a child. But at the time, it would have been unlawful for that for that conception to have taken place. You follow me?
I do.
That would have been against the law under our law for that to, but they've stayed together. Well, that was technically a rape. And of course, when you start saying, well, there's different types of rape, everybody says, no, rape is always rape. Rape is rape and rape is rape. But rape is not. There's different shades of rape, and then you get in big trouble if you start saying that. But when you peer below the surface of terminating parental rights of rapists, you see that it goes all the way down to the consensual relationships, and then they want to have it where the person doesn't need to have had a conviction. They said, well, they should never have had a conviction of rape. So what they want to have the victims industrial complex, they want the people to be able to come in and say, years and years after the conception, where the person may have been participating in the child's support, providing child support, they want him to be able to come in and say, well, that child was conceived against my will, and he's been paying child support for the last 8 years, and he's been a part, but he shouldn't have done that to me, and you should terminate the right. That's just not right. And those are the hidden landmines that I worry about when you start digging below the surface, because they bring them into a civil proceeding because it's not criminal in nature. They don't file any charges. They file a civil petition for termination. You're not entitled to indigent counsel. So if you're working down at the Octopus Car Wash for $11, $7 an hour, whatever minimum wage is, if you're working down at the Octopus Car Wash, you don't have any money. So they put you in a position where you have to defend yourself against something that was alleged to have happened 9 years ago, and they terminate your parental rights. And And the evidentiary standard is by less than what's required to convict a person. It's not beyond a reasonable doubt. It's either by preponderance or clear and convincing, one of those lower standards. And they put very tight timelines on these proceedings. The petition has to be filed. The court must hear it within 60 days. And somehow the person's going to magically be able to muster a defense against something that was alleged to happen a decade ago. It's wrong, and it doesn't resemble due process, and the victim's industrial complex is wrong, in my opinion.
Larry, have you ever considered doing a filibuster? I think you could have just kept going. You could just do that, and you could just keep rambling shit for an hour. And get your pink tennis shoes out there on the floor.
But I see these people coming with these legislative proposals, and they put on this pony show about, well, everybody agrees that rapists should be terminated. Well, of course, everybody does agree with that, but that's not what you're proposing.
Right.
You're not proposing that. You're proposing to take the entire universe of sexual offenses, and you're proposing to put people into a civil process where they have no rights to speak of, no representation, and you're proposing to take away their parental rights, even in cases where they've been supporting the kid. That is wrong. And nobody will call them out on it because you're not supposed to say anything against the victim's advocates. That's somehow un-American if you do that.
Ashley, let me ask you this question. When you were doing the intro to this particular piece, you were saying that this was more narrowly tailored versus the Tennessee, and I think you said another state. They're making it more broad, I guess, of that this applies to more people. I can't personally find, the way that this is written, the way that I understand it, a problem with the New York one. Are there problems with the other ones?
Anytime we have where you just are doing blanket removals, like they're doing in Tennessee, where you can't reside with any of your children and they're tearing families apart, those are extremely concerning. And I'm with Larry. There could be trapdoors in this one that we haven't actually seen. Even me looking at the language and going, wow, even though they did by petition in order to show cause, I'm not so sure that they actually spelled out criteria like they need to. So I think that could be an issue. But at least it is not to the level of, okay, you can't reside with any minor children, including your own. At least it does not say that. It's actually way more specific.
Which is what Tennessee did. Yeah.
Okay. And does this apply post all of your time, or is this even while you're under some sort of form of supervision?
This particular one, this New York or the Tennessee one?
Either or, because the reason why I'm asking that is because Georgia has language while you're under supervision that you can't have any contact with minors, including your own children.
And New Mexico does too. No, the Tennessee one, they were done with their supervision. Almost every single person on there was done with their supervision, weren't they, Larry?
Yes,
I don't think any of
the plaintiffs that they selected were all done with their supervision. This applied to everybody on the registry if you had a victim under 12.
Correct.
And I asked you somewhere in the past, Ashley, one of the previous times that we were together, that I said, and you have a constitutional right to your family, and you said, yes, you do. How does this not then violate the Tennessee one, New Mexico, probation in Georgia? How does that not violate that stance?
It is my position that it does, as do undisclosed romantic relationships, and the courts are split on a lot of that, but I do see this as being an area that we will be fighting on the probation side, at least in New Mexico. I'm not sure about other states.
Sure.
It's already been fought in California on the romantic relationship side. But
so this would be two consenting adults
right.
doing whatever, and you don't tell them and you get in trouble for this, even if there are no kids anywhere in the picture?
Sometimes it's if they have kids. Sometimes
Sure.
It's just if it's an undisclosed romantic relationship. Either way,
yeah,
I think there's issues. I think you have a fundamental right to procreation, and I think you have a fundamental right to marriage. That may be a personal opinion, but also as a lawyer, I believe you do.
So on this Tennessee thing, let me just give you an example of things that don't get thought about because the advocates are not there. I don't know the specifics of what Tennessee does and what it takes to put a juvenile in adult court. I only know about our state. I know that you don't succeed very often trying to get a juvenile put in adult court here, but it's a very high mountain to climb. But let's say Tennessee is one of those states where all the prosecutor has to do is file a piece of paper saying I'm charging this person if they're over 14 as an adult, which is the case in some states. They can just automatically do it without any type of due process, just from the prosecutor's decision. Well, let's say that a person in Tennessee was put in adult court at age 50, and that they had a victim under 12, which would not be so heinously impossible to imagine for a sex offense, because an immature boy at age 15 could be messing around with a girl that's 2 weeks shy of being 12 years old, and that would not be unheard of. Well, so that person is convicted of a sex offense in Tennessee, and no one was there asking those lawmakers, well, what are we going to do? Because you say that if they had a victim under 12, that they can't never be around it. Well, what if they were only 15 at the time they did their sex offense with a victim under 12? Nobody was there asking those hypothetical questions. And that's how you spot the things that are going to blow up on you later. Is you have to be critically analyzing the legislation. You have to try to imagine the worst case of what could happen, and you have to be there posing those questions. And when they said, "Well, the prosecutor would never do that," you say, "Oh, yes, they actually would. They actually would. I know they wouldn't do it in Sandoval County, New Mexico, but they would do it in a whole bunch of other counties in our state."
Absolutely.
The listeners won't get that joke. Sandoval County is pure as the wind-driven snow. Hey,
that's my hood.
The district attorney there is so pure and wind-driven. And those who've listened to this podcast, I've actually said that there are good district attorneys out there. I've expressed admiration for those that are, but they're not all good. And I've expressed dissatisfaction with those that are not. But I've expressed, given accolades, particularly to my old colleagues up in Boulder that I thought were very, very ethical back in the day. But yes, this is an example of why that advocacy is so important. Someone has to be watching what they're discussing, and someone has to be posing hypotheticals that haven't been thought of.
You're absolutely right. And then, like you just pointed out, what I've seen lately on a lot of the legislation in various places is, well, the prosecution's not going to be like that. Probation's not going to be like that. The court's not going to interpret it that way, but they are. I mean, we see this on the parole revocations. Oh, no, they're just going to let them out, and they don't. So I think that definitely as part of any legislation, you need to ask those questions and then consider the worst case scenario. What happens in this instance? What happens in that instance? And that's how you tailor legislation.
And that means you can't stay behind your computer screens solely. You have to actually go in person and talk to people and build relationships so they will want to hear what you have to say.
I'm not doing it.
Absolutely.
Are we ready to move on?
Not gonna.
Just not. I'm boycotting. Not going to do it. FYP, Larry.
Not going to do it.
I'm going to do it my way. My way will win, and I will show it to you.
Yeah. So you just for those in the South, it's I ain't gonna do it.
Yeah.
Ain't gonna.
Well, Will is definitely, his ears are perking. I was like, hey, they're speaking my language now. Ashley, I suppose we should let you go now. We're 30 minutes past the time that you said that you would stay with us.
Well, I appreciate you guys having me as always, and I'm really looking forward to us keeping tabs, especially on the civil commitment with Galen, and see how things shake out this week. I'm sure it's going to be a hot topic, and I'm going to be curious to see how this whole thing plays out. So I appreciate you guys giving me the time, and as always, thank you.
We will also give a shout out that Ashley will be with us on Monday night for the NARSL in Action call that will be on from 7 until 9 Eastern time.
And the people that are catching this podcast will know about it then after it has been.
Well, there'll be people who'll get this podcast tomorrow afternoon on Sunday before the NARSL in Action. So there's about 50 people that will know about it.
Give or take, yes.
So that's worth $1 a month, right?
Correct.
Okay,
I'm on board with that. Thank you, Ashley. Have a great night.
You too. Bye.
This first article comes from CNN and is a California man says he was beaten after being mistaken for a suspected child predator. This guy actually looks like Johnny Depp from Pirates of the Caribbean, a movie you have never heard of probably. But the story is pretty amazing that the guy's in a bar. Someone comes up to him. He's a little, he says he's kind of hammered, not even just tipsy, and says, "Hey, man, I need to speak to you outside," and proceeds to beat the shit out of him after having a little conversation. He's like, "No, that's not me." And then the guy's running away, and they're still trying to beat up the guy because he says, "Hey, you look like this dude on the registry." I don't see a problem with it, right?
I don't know. We can move on to the next article.
Could you tell me why this is a problem? Could you just speculate? Could you step outside of your comfort zone and come up with a reason why this might not be such a good idea?
Well, we've said for so long that the registry, the public, the dissemination of the information is dangerous to the health of the people who are on it and their families. And for those of you who don't care anything about the former offender, hopefully you'll care about the innocent family members. But this is an example of what we say our fears are, that the retaliation and oftentimes the violence that goes on, there's no clear connection. They don't proclaim they're doing it because they're on the registry. There's a low level of background violence that's happening all the time. In fact, a guy just left this state because he's got a neighbor that's a police officer who's been going door to door stirring up trouble. Now that's a couple steps below chasing someone down, beating them up. How many lashes over the head he said he suffered. He got said 20 to 25 blows on the back of his head, and I'm not equating that to that, but that the public dissemination causes people to be able to do things that they shouldn't be able to do. We've always had sexual offenders in our communities, always, but they weren't on a list where the public could click a mouse and see their address and their image and go out and target them. And that's what's happening here. He got targeted. There is a striking resemblance.
Certainly. Yeah, I'll totally accept that. So I wonder then, could there be, if someone were so inclined, I'm not saying that this guy would be, but it seems that somebody could be so inclined to say, I'm going to sue the shit out of the state for allowing this to happen to me, that because they made this information public, that I had my civil liberties violated by this man punching his fist into my face repeatedly because they posted a list that made it, had this guy public that looks like me.
I wish there were more litigation in that area. The litigation that there has not been successful. I haven't analyzed to know if it's been incorrectly, if it's been presented properly. The defense to that the state will assert is that, there's no direct linkage to the registry. I mean, people get beat up all the time, and unless they proclaim they're doing it because of the registry, in this case, there was such a proclamation.
Correct.
This case will be treated differently because there was the proclamation, but the state generally has immunity for what they do, and the registry is the law of the state, and so the officials are largely immune for. I mean, what would you want them to do? So the lawsuit goes. I
get that side of it. Yeah, but I get that side of it, that they like, it's kind of vague, so you can't point to it. But this guy says, we don't like your kind in here, and then proceeds to beat the shit out of him. So it's like, we need an ambulance chaser guy that collects, helps you collect checks from, having some car that mowed you down and broke your legs, and they were, not driving with the right certifications, whatever. And they take 50%, whatever. Get some ambulance chaser kind of law firm because this guy was wrongfully beat up because the state published that information.
Well, and within our listening audience, you'll have people who will. I mean, guns don't kill people; people do. That's the position of the registry didn't beat this guy up. The person did. When you're drinking alcohol, who consumes the alcohol? Is it the person, or is it the bartender pouring it down your throat with a funnel? The state merely provided information, they would argue, to enlighten their citizens. And this is not me saying that. I'm just putting myself in the role of a defense attorney for the state. The state will argue that we merely provided information intended to help our citizens be safer. That's our intent, nothing more. And the fact that people are going to misuse that information, their defense would be, that's not our responsibility, no more than it is the person who goes out and does something with it. The gun manufacturers, they're not hoping that somebody gets killed at the end of their weapon for a sinister reason. It does happen, but you don't hold the gun manufacturer responsible for that. The person who goes out and pulls the trigger, right?
Totally.
Right. I mean, I'm just trying to tell you that's what their
I know.
defense.
I know. I understand. I mean, same thing with cars. Somebody, unless there's an actual malfunction, the car didn't kill. Somebody was negligent in their driving, like driving in the interstate in a torrential downpour without their headlights on. But this just, to me, this just feels different. That this was literally targeted as a. I mean, we've talked about hate crimes recently. This actually goes to exactly what a hate crime would be.
Well, it does, and one of our podcast supporters said that he didn't believe in and that this should be a hate crime. But I did pose that question. But the state will defend with vastly superior resources to anything that we could muster. Yeah. They will defend, saying that we simply are providing the information. We're not encouraging. In fact, we have disclaimers on our website that says this information is not to be used in such a manner, and that if a person is going to willfully break the law and do that, I mean, that's on them. That's not on us. I disagree with that. I think that it's a tool that would not exist, but then you can make that argument about a lot of tools that wouldn't exist. But this is a state operated tool that allows for people to inflict great harm and discrimination and all levels of retaliation and vigilantism. And this is not the type of nation that I think we should be, or we claim to be, that we provide this type of tool to our citizens to do what, basically it's almost a license to do what you want to do. There are the disclaimers saying not to misuse this, but tell me how often someone gets prosecuted. I mean, it's very rare.
Certainly. Well, let's move on. This is just kind of like a public service announcement. It came to my attention only in the last couple of weeks. There is another podcast, and it has been out for quite some time. I've listened to a handful of episodes. It's worth a listen. It's more, I guess, like on I'll call it the stories side of things of life on the registry, so to speak. It's called the Pariah Nation podcast with Cowboy and Karma. Maybe you guys could go give it a listen and check it out, and it might be something up your alley. One of our listeners, he said he's like binge listened to all of their episodes going back. They started around January to release their episodes. They've done 20 or 30 episodes or so.
And what was that analysis as a result of listening to all of those? What's the feedback?
Captain Crazy likes it, and he listens to all of the offender related podcasts, because there's also the registry report. Yeah, registry report is the other one. And he likes listening to all of them, and he is a fan of hearing it more from the humanitarian side, where they're talking stories about life on the registry or being a registrant in prison and so forth. So just wanted to bring it to y'all's attention in case you didn't know about it. We then have an article coming from The Hill. Current and former prosecutors respond to Barr's concerning comments on progressive DAs. I'm assuming, Larry, that this is all about, because I think it says there at the bottom, signers of the letter include Philadelphia DA Larry Krasner. So Barr is not in agreement with what the progressive prosecutors are doing in trying to make prison less awful.
Yeah, this is U.S. Attorney General Barr that we're talking about. He's trying to stir up hate over prosecutorial discretion like it's taking place in Philadelphia. So in a speech at the Fraternal Order of Police last weekend, Barr blasted unnamed DAs who have declined to prosecute some nonviolent offenses as, quote, anti-law enforcement. And so there was a public statement to make it clear that U.S. Attorney General is being condemned for that, and some significant people have signed off on that. So
what does this mean for us? Why are we bringing this article into the podcast? Is this my fault or your fault?
Well, it's my fault, but I'm trying to illustrate how that those who stick their neck out and do try, like Krasner in Philadelphia and New York County DA Cyrus Vance, some of those people, the grief that they're taking from the law enforcement apparatus, particularly the highest-ranking law enforcement official in the United States, the U.S. Attorney General, that is something that I find very troubling. But this is what we have at the top right now. So it's just merely an informational piece.
Fair enough. And just to like fill that in backwards, we have talked repeatedly about the success statistics of prisons systems in other nations, and then we talk about ours and how atrocious it is, and then we have a handful of outliers that are trying to make things where if you are going to get less than 3 years, you don't go to jail or prison at all. You get diverted, and then you've got William Barr, the top official, saying that these guys are anti-law enforcement. That's really awesome.
I mean, he's entitled to that opinion, but it's very irresponsible.
Of course.
And it should cause a little bit of pause for people who thought that this administration was going to be so pro justice reform. Because I remember a lot of people said, "Oh, well, we've got a new administration." And I said, "Well, no, they campaigned on being tough. They campaigned.
Yes, they did.
And I don't know where you draw this conclusion somehow or other magically that they're going to be soft. They've been issuing directives for the entire time to be tough, to seek maximum penalties, to stack charges at the federal level. Now we're talking about federal prosecution. I don't have anything to say about what's going on in your particular state, but at the national level, this administration ran on a campaign of law and order. And that's exactly what they're delivering. And they're continuing that tough talk to this very day. So if you are for the reform, which you claim you are, you may want to think about whether this administration accurately represents you.
I guess here's the point where I would throw in the quote from Trump saying, "I am the law and order candidate," right?
Yes. So
I am the law and order candidate.
All right. Do you want to talk about some really deplorable conditions in Mississippi?
I sure don't want to, but we have it on the agenda.
We do. We have a couple articles. Go ahead.
It pains me to talk about these type of prison conditions, to imagine that the United States of America, that this is going on in our prison, one of our state prison systems. And it's going on in many of our prison systems, not just this one, but this one stands out.
We have two articles back to back from ProPublica. Some of the country's worst prisons have escaped Justice Department action. Not terribly long ago, we talked about their neighbor, Alabama, being like the worst of the worst, but this is the worster of the worster. And these places are unbelievable, and they are hell, and they are violent, and you've got to go in there prepared to defend yourself, and then there's no guard support that you can have a safe Club Med vacation while you're visiting.
Well, the second one is particularly sad because I guess there was a inmate that was beat to death, and while they were crying out for help, there was no help to be offered because of the lack of staffing. Did you catch that?
There was a guy that got. Yeah, I did. There was a guy that got set on fire. I mean, how? Okay, when your family comes to visitation, they get not strip search, but something close to it. So how did an inmate get gasoline to throw on another inmate to burn him? Unbelievable that this could happen.
Probably through some of the machine shops that they operate.
Correct.
Mississippi operates a very, very labor-driven system where they put people in more jobs that are raising crops and tending to animals and they make license plates, I'm sure, but they do a whole lot of stuff that would have inmates in labor roles and some even go off the prison grounds depending on their security level.
Of course, and of course that's where they would have gotten it. But then when they came back in through the shakedown shack, whatever, you would then think they got strip searched, to make sure that they weren't suitcasing a phone or dope or whatever. So what did he do? Suitcase gasoline?
Well, there's a number of ways. I mean, it could have came from the facility itself. I mean, if they're operating a prison facility that has vehicles, I mean, they would have to have a motor pool. They'd have gas. I mean, there'd be any number of reasons why. And despite the shakedown procedures, I mean, you're going to have human failures of lack of attention, diversions from distractions that inmates are cleverly known to pull off, and it just apathy and all sorts of things. Why you saw stuff go through through shakedowns that shouldn't have gotten through. The people
absolutely.
People learn who's watching what and what they and how to work the system, and you can't have a prison if you're going to have movement in a prison. You're going to have you're going to have a lot of stuff moving around within the prison. If you cut down movement and lock everybody down, those prisons are far more expensive to operate. And then the movement takes place through briberies with staff members and guards, and you're just not going to have a prison. But this is so egregious that the staffing ratios are so ridiculous that they didn't have. How bad are they? Well, it said 1 to 23 or 1 to 29 for one staffer for every 20.
That seems really horrible. I thought it was something in the single digits for state prisons in Georgia, but it's in the mid double digits for the private prisons in Georgia. But 23 sounds horrible.
And the not being able to respond to someone's being beat to death is really, really sad. And it says the starting pay for a correctional officer at Southern Mississippi, which this article focuses a lot on there, it is $12.33 an hour. And it says, in contrast, the salary for a kitchen manager at nearby Hardy starts at $36,000 a year, which is $10,000 higher than a new guard would earn at $26,650. I mean, and that says something about Mississippi's priorities.
Certainly not. Maybe they should hire Joe Arpaio for some of their administrative roles there. He could probably teach them a thing or two.
Yeah, he sure could.
Wow. Dude, we are really, really horrible people.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible.
We should probably move on and talk about the Wisconsin bail system, because I know that you really don't even have much of an opinion on the bail system, do you?
I don't.
This article is from Wisconsin Rapids Tribune, and it's Wisconsin's bail system burns the poor, opponents say, as they call for reform. As we have talked about before, and I really don't want to beat a dead horse, but let's talk about this just one more time, that if you are a poor person and you end up incarcerated to some degree, even a $25 bond could be beyond your means, which then causes you to lose your job, which causes you to lose your apartment, which all of your effects in your apartment get thrown out on the street curb, and you have to pretty much start all over just because you couldn't come up with $25 to get out of jail before your trial.
Well,
how'd I do?
You took the extreme, which those extremes do exist in real life. There are people, if you go to a jail roster where they allow the amount of the bond to be posted, you will see some very low bonds in the $100 range. You seldom see anything lower than $100, and you do see people who are sitting in custody on very small bonds, and that's one side of the tragedy. That if you shoplift a $9 item from the local Kroger store and they take you in rather than giving you a citation and you have a $100 bond, well, theoretically you shoplifted the $9 item because you didn't have the $100, and that's a tragedy that you sit in jail waiting to go to trial. And oftentimes those cases are played out after so many days in jail for credit time served. But the flip side of that is that that's not an ideal setting, because being able to post a bond gives a distinct advantage to a person who is able to have some economic resources, or at least collateralization for a bail bondsman, so that they can get out on bond. It gives them some additional participation that they wouldn't have in their preparation for trial when they're on the street. But the flip side of that is the other extreme kicks in when a person doesn't have the option to post a cash bond. When they switch to these non-cash systems, then they create a whole lot of new complexities that cause grief for people, because they have to go through an evaluation process. So under the old system that was primarily driven by monetary bond, a lot of offenses would have a preset bond. Shoplifting less than a certain amount would be $100. So the judges and the prosecutors have all agreed that these are called jailhouse bonds. So there's a schedule of bonds already available for a whole host of offenses. So the people were able to immediately post that bond and return to the workforce. So if you had a $2,000 bond for some low-level felony or some high-level misdemeanor, and you didn't lose your job because you didn't sit in jail waiting for this evaluation to take place because you get picked up on Friday afternoon, and the pretrial services they come in first thing until Monday morning, and they have a backlog of people who got arrested or for the last 48, 72 hours, and they have to go through those, and they have to score them. And they have to run criminal histories, and they have to investigate their ties to the community to see if they're fit to be released on their personal recognizance. If they're not, then what accumulation of conditions can they impose on them? So while they're doing all that, the person is calling in if they can get to the jail on their first day of work, absent work, the second day, and the third day. And then if they can't call in, they forfeited their job because they consider their job abandoned, and they've lost their job because they can't get out of jail because the process works too slowly. That's the downside to that. Well, when we talk about unintended consequences, those are some of the unintended consequences.
And this is bad. Why?
Well, is it bad if you lose your job because you can't get out of jail? And you're supposedly presumed innocent, right? You've been accused.
I thought that was you are innocent until proven guilty, as I understood it.
So although I am one of the people who believes that a system that's entirely driven by the monetary, the cash bail system we have largely in the U.S. has a great number of flaws. What we've replaced it with also has a great number of flaws.
We got to figure out a way to fix it, Larry. That's the answer.
Well, that is the answer, but maybe one of the methods would be on very low level offenses. We just wouldn't arrest people. We would give them a summons. That would go towards the beginning of a solution. And then where there are low cash bonds on the old jailhouse bond schedule, it might be that we would just agree that those people automatically get released on their own recognizance, barring, say, a violent felony, which is truly violent, and we define what violence is in the last X number of years. If the person is shot from a motor vehicle, for example, or if they've used a weapon in the commission, or if they beat the little old lady over the head with a slapjack, or whatever you call those things, or if they've engaged in an act of violence, then that would cause that person to be held for further scrutiny in terms of what kind of conditions they could be released on. But what we have replacing the cash bond system is no panacea. It's fraught with a whole lot of problems.
And I was then going to bring up that in talking about that, the article 2 articles ago where we were talking about William Barr saying that these are anti-law enforcement, the Larry Krasners, who have tried to put those things in place, and they're getting pushback from the legislature in Pennsylvania for Larry Krasner's case of trying to do things like you just described.
Well, not only did they get pushback, they passed a statute that gives the Attorney General's office the power to step in to prosecute things that the local people have declined to prosecute. Now, these are normally the people who claim they believe in local government being smarter and closer to the people and able to make better decisions, but they magically drift away from that when it's something they disagree with.
Fascinating. The next article comes from courthousenews.com, and this is Governor Newsom out of California signs a new Newsom signs use of force reform into law in California. I remember us covering the proposal of this bill several months ago, and the way that it was worded felt backwards to me. So this is something that then gives a little bit more teeth to hold officers' feet to the fire, and if they do something like, I don't know, shooting somebody, and giving some prosecutorial teeth to prosecute officers that act like that.
Well, it is a step in the right direction. The reason why I wanted us to talk about this article is because I have said and pontificated for so long that it is time for us, the citizens, to take control of the police. The police are not this renegade force that should be allowed to use any tactics to use any weaponry, to use any procedures, and to interact any way they want to with the citizens. They work for us. We will determine what equipment they use. We will determine when and where they deploy that equipment. We will determine what they're allowed and not allowed to do. And this is a step in saying, police, actually, you don't get to make all the decisions. You don't get to decide everything about when you can discharge deadly force. And this is giving them some legislative guidance on what they're not allowed. It's a step in the right direction. I don't see it as a cure-all, end-all, but it is a step of a state beginning to say, we're not going to just accept the fact that you say you needed to shoot the person. That is not good enough for us.
It feels, as I would understand it, so we are the taxpayers, therefore we pay the salaries. We elected the sheriff. It feels like we are sort of like the board of directors for the company. Like maybe the sheriff is sort of like the CEO, but we are the shareholders, and we get to say what happens. I think that might be a decent analogy.
That's a great analogy, and that's what I've been saying. But the police have convinced the governing structure. They've convinced that they should be their own decision makers about everything. That somehow or another that we're not competent enough to exercise. Can you imagine any other employment relationship where that would be the standard? Try that on your job. Those of you who have jobs, go into your boss Monday morning and say, I've decided that our protocols are changing and that we're going to do it this way, and I'm going to do my job this way, and I'm going to use this piece of equipment, and I'm going to set this as my policy, how I interact with customers, and that I will hang up on customers when I deem appropriate. And you don't get any to say. So try that and get on next week's podcast and tell us how well that went over for you.
I mean, I see to a certain point that they should have at least some sort of say. There should be influence there. They should have a seat at the table. But if they're completely dictating and saying, "Get off my lawn while I make these policies that affect your life and death," that does seem like an overreach.
Well, I mean, that's the age-old debate about how much the employees get to be involved in policy making for their workplace. A lot of employers say minimally, and employers like Facebook and some more enlightened employers say more so. But at the very minimum, since we have to pay the salaries as the public, and we have to be responsible for the misconduct, and we have to make the citizens whole that have been abused at the hands of the police, it only stands to reason that we get to decide what the policies are on how our officers who are being paid by us interact with us. I mean, to me, it's just a no-brainer. I don't understand why there's even such debate about it. It's really straightforward. If we make if we make being a police officer too difficult, we won't be able to fill the positions. The market will let us know when we make it too difficult to be a police officer. It will tell us.
That sounds like a libertarian point of view.
Well, it sounds like to me like a capitalist point of view. That's what everybody says is the answer to everything. The free markets, the free markets are the cure. Well, I agree with you. For the sake of this discussion, I agree with you. Let's let the free market tell us when we are putting too many controls on the police. Right now, you have a whole lot more applicants for police jobs than you have police jobs available. Now, I know that they don't make it through the process. I understand that because somebody's going to say, "Well, Larry, if you would just quit being such a smartass and you would actually get better informed, you would know that there's an officer shortage." I actually do know that there's an officer shortage, but the reason why there's an officer shortage is because of the very strict criteria. They've begun to liberalize a little bit about if you can use a little bit of marijuana, and that doesn't automatic exclusion. But they have all these fitness and agility tests. They have these mental batteries they put people through, and if you can't shoot right away, they have all these simulators that they put them through, and they tell you that you would have been dead 14 times because you don't fire quick enough, so you don't pass the fitness test. If you actually would let people who are a little bit older be police officers, go through the recruiting process, maybe let them be just a tad bit heavier, because all society is not trimmed 22-year-old, good-looking, beefy, all-American athletic. Yeah, I mean that's not representative of society. So if you would actually hire some people in their 30s and 40s and who maybe can't run quite as fast, but maybe have some good life experience on how to interact with people, maybe they smoked a little bit of dope. Yeah, you might find that you'd have a much more diverse police force, you might have something that more represents your community, and you might have a police force that's able to actually to relate to the people in your community because they actually look like the community. We're not all 22-year-olds that live in a city, but take a look at your police force, particularly out west here. I can't speak for back. I know I see a lot of pot-bellied cops when I'm back in Georgia, but when you encounter a police officer on the Albuquerque Police Department on patrol, you're more than likely going to encounter an officer in their 20s, very healthy, very fit, and very, very conservative looking in their appearance with that cropped hair, and that's what. But that's not what the community looks like. I'm sorry to tell you. And it looks really pretty and everything, and it's nice if you like to look at a hot officer, but that's not the community.
Sorry, can you describe Georgia police again?
Potbelly, the sheriff. That's the night the lights went out in Georgia, and the big potbelly sheriff grabbed his gun and said, "Why did you do it?" Well, every time I've encountered, when I go to the North Georgia Fair, which the Cobb County sheriffs handle they handle those huge crowds. They do a great job, but every one of them weighs like 250 pounds, and they've got their bellies hanging over their belt. And I'm looking at it, I said, you wouldn't see that in my hometown.
We're gonna have some hate mail coming in. Larry, before we get too far out of hand, the next article comes from LAist. I don't know how to pronounce this. LAist.com. LA rules about where homeless people are allowed to sit and sleep could get even more complicated. I'm interested in this because I've heard Paul Dubling say you do not have a constitutionally protected right to housing. Okay, I get it. And I just think that maybe the framers of this whole thing were like, well, we would never get that cruel that people couldn't find a place to stay. But in California, they have 27,000 people experience homelessness in the city, and they have approximately 4,000 beds for single adults because beds are already reserved for families and so forth. You just going to leave them on the street then, and then they're going to restrict that they can't sit or sleep here, and then the neighborhoods are going to run them out because we don't want those people in our backyard either. Where are they supposed to go?
I haven't figured that out. The 27,000, I think that's just into Los Angeles. That's not California, just in Los Angeles.
No,
but it's one of those things where the ACLU type organizations have been fighting. Even here in my city, where they've tried to make it where you can't panhandle, and the ACLU keeps shooting them down on that. You have the right to ask a person to help. So here they keep passing these ordinances that you can't panhandle, and every time they pass one, the ACLU files it for an injunction, gets the injunction, then they go to trial and they win, and they go back and craft another one, and the same thing happens, and they don't learn anything. They do the same thing again and again. But the big point is that how does this happen in America? How does this happen? Those of you who listen to the podcast and go way back, I mentioned on some episode that in 1970 we had virtually no homelessness in this country. We had through the war on poverty in the 60s, we had largely eradicated homelessness except for the people who were transitory by nature because they were moving from city to city to get a job, and they may be staying at a shelter so they can get hired on as a temporary. But homelessness was largely not existed in 1970. How is it that just a few decades later, we have to be at least as smart as we were in 1970? How come we can't find a way to find shelter for our citizens in a very wealthy country like this? I don't understand it.
Is this a problem not specific, but exacerbated by California's, specifically these particular areas like the Bay Area, where they have ordinances where they can't build any sort of higher density residential areas that might help alleviate this? Do you think that this is related to that?
I think that's a contributing factor. I think that there's no one solution to homelessness. Everybody looks for the magic bullet. They're probably the difficulty of building affordable housing is a factor, but we've largely abandoned any notion of public housing assistance in this country. We dramatically underfund the Section 8 voucher programs. The demand far outstrips the available slots And as far as building public housing, that's a thing of the past. I mean, we do some low income tax credit properties, which is the low income threshold or way beyond these people's ability to pay. Low income means what you would see on those charts for low income, because I used to be in the low income housing business, is shocking as what qualifies, because it's based on the median income of your area, and if you're below a certain percentage of the median income, that person's considered low income. But these people have virtually no income except from the plasma centers and except for their panhandling, and we've got into a condition where we have hundreds of thousands of people that are just destitute. And it's not possible to pull themselves up by their bootstraps, as the old adage goes. We're in a modern economy where skills are needed, where you needed to come into work prepared to work, properly dressed, properly groomed, and these people who they're broken individuals, and they need far more help than we have resources out there to transition them back to productivity. So what we do, we just let them meander the streets, and then we get mad because we find urine and excrement, and we find these problems associated with being homeless. But what would you expect if they have nowhere to go? I was with my brother a few months ago in Georgia, and he was mad that this lady was sitting out under a shade, one of those. I forget them. I had lost for a word, but anyway, she had a little tent over her, and he said she's here every day. And I said, well, of course she has nowhere to go. Where would you like her to go?
He just doesn't want her there.
Yeah, he said, well, I guess it bugs me. I said, yes, but she has nowhere to go. There's no shelter.
And no means to get there.
There's no shelter in this town. If she goes to a business, they're going to tell her to get off the property because they don't want it to interfere with her. I mean, where do you want her to go? It's like, well, I don't know, but she shouldn't be there.
Right. Can you, I don't want to spend too much more time here, but can you help me understand when people say that when you do give these kinds of hands out, that you're then just perpetuating that, hey, I got this handout for free, I'll try and get the next handout for free. And they just end up sitting on their couch watching television all day, just taking handouts from the government. And that's my taxpayer money. And I don't want them doing that with my taxpayer money.
Well, there's some truth in that. There's some truth in that. People, as it becomes easier and easier for people to survive without having to live a structured life, there would be a segment of people who would do that. But we don't punish people for bad decisions they make. I don't like paying for you because you smoke. That's my tax dollars. That's my tax. I don't like paying for you because you overeat, because you weigh 350 pounds, and because you're hooked up to every kind of apparatus that's costing me tens of thousands of dollars. But I do it because it's the right thing to do. I mean, but yes, there would be some people who would take advantage of it, and the spirit of the rehabilitation. If we offered true rehabilitation, if we offered rehabilitation centers where people could go to where they could get actually training and get job assistance and transitional assistance to be back in independent living, there would be some people who would take advantage of that, and they would use drugs and they would game the system. Absolutely, that would happen. But that doesn't stop it from being the right thing to do.
You just have to accept it as part of the overhead, I guess. I don't want to say collateral damage, but just part of the process of having it done.
It would be a part of the human condition. There are people who they're defense contractors who overbill the government. That's a part of the human condition. That never
happens. Come on, man, that doesn't happen.
There are people who charge for asphalt that they never lay. That's a part of the human condition. Of course it would happen. But there would be a whole lot of people who would actually benefit from it, and they would begin to pay taxes, and that would offset the people who game the system. We would have more people. I'm not convinced that of the hundreds of thousands of people that out there that they're all losers. I've talked to enough of them, and I don't believe that. I believe that they've had bad things happen to them where they've either made bad decisions or someone else has for example, the position that people that our audience is, they've made a bad decision, and then they're forever forbidden to reintegrate and function. Well, you're not the only one that's had bad things happen to you that are beyond your control. And so to me, it's very, very selfish and unforgiving to think just because someone makes a bad decision that you shouldn't help them. If that's the way you feel, then you're a selfish person.
Definitely. Our penultimate, and I shouldn't even say that because we have the Scalia clip here coming up, but the penultimate article is out of WNYC Studios. And again, just like before, this is more of a shout out just to make sure you're aware of it. I guess you could kind of call him our our shining star of being in the public eye is Guy Hamilton Smith. He was on the podcast, I don't know, 3 months ago. He came on, I think, just before the conference in Houston. And he ended up getting on this program from WNYC called The Takeaway, and they're talking about the inequity of sex offender registries. And it's not a terribly long listen, maybe, I think, 12 or 15 minutes. Awesome listen. He does an incredible job. He is super duper humble on Twitter. If you happen to see that, he's like, oh my God, I can't believe anybody would listen to me. I sound like a complete derp. And anyway, he's a pretty stellar dude, very informed on the subject, and is working for the Sex Offender Litigation and Policy Resource Center. And he's trying to help people write the laws that make our lives better.
He is absolutely a dynamic speaker, a very, very nice guy, and I would encourage people to listen to it. And he's a super guy.
Yep. All right, let's do Scalia. Are you ready for Scalia?
I'm ready. This one's going to be a short one because I got a long one coming next week.
Outstanding. And I don't have music to go along with it, so you have to put up with that.
When you call yourself a textualist, that's not the same thing as the popular notion or the popular term that I think many lay people know, which is strict constructionist. Can you explain that?
Oh, yes. I have never been a strict constructionist and advise no one to be a strict constructionist. Strict constructionism gives a bad name to textualism. For example, if you were to interpret the First Amendment strictly, you would come to the conclusion that Congress can censor handwritten letters because it says Congress shall make no law abridging the freedom of speech or of the press. A handwritten letter is not press, it's not speech, so Congress can, of course not. That's not what it means. Speech and press is meant to cover the ground of expression.
Isn't this even this whole concept of he is making his own level of interpretation on whether he's a constructionist or a textualist, where other people doing something similar of does the body of work evolve forward, just like Andrew Torres was saying. He's like, look at all the precedent from yesterday, last year. That moves the whole conversation forward of where we are today of an evolving standard of decency. Isn't he then doing the same thing just within his own realm of what he's comfortable with?
That was precisely the reason why I put the clip in here, is because Scalia says that you're not supposed to read anything into the text that's not there. And there was a lot of debate. Don't remember exactly. My history is not good enough to tell you how long they worked on the Constitution and the Bill of Rights, but they spent a lot of time. And according to Scalia doctrine that he's espoused on other clips we've played, you're not supposed to read into it what's not there. And they didn't say that. And certainly they should have been smart enough to say that if they intended to protect that level of speech. So what he's doing is he's looking at what he believes are intent, which is his job as a judge to do that. So I'm not saying that he should not do that, but I'm just pointing out that no one is a strict anything. In fact, I'm going to magically become the biggest textualist you've ever seen in some of the litigation we're going to be doing in New Mexico because it suits our purposes for litigation. Sheriffs are doing things.
That makes you a hypocrite.
Makes me nothing of the kind. It makes me that it makes me follow the doctrine that suits the purposes for the claims that we're asserting. And we're asserting that since there's nothing in the statute that requires a person to respond to an orange flyer that's left on their door, that they don't have to do that. If the lawmakers had wanted those flyers to be left and for someone to have to respond, there are states where they say that you must respond to any inquiry by a law enforcement officer. We don't have that. So I'm magically going to become a textualist. Well, Scalia magically, when the First Amendment was interpreted, he said, well, clearly, I mean, they didn't say it, but clearly that's what they meant. He's able to look beyond and what the text is, and he's able to expand and say, well, that is the intent. Nobody's 100% anything.
Interesting. But, here you are pulling out a clip where he, as you know, since we've been covering these various different things, here it is where he's almost talking out of two sides of his mouth, from two different times, week to week, whatever, but still saying it's okay to do it here, but not okay to do it here.
Well, but like I say, none of us are that way. I'm going to be a textualist when it suits the agenda that I have for litigation. And
isn't there a difference there, though, in the way that you're doing it? You're like consciously making a decision that I'm going to follow this policy here, where I don't think in the clip that we just played, Scalia is taking that. He's like, no, that's not what that means. He's not doing it strategically. He's doing it. That's just like the framework. That's the bedrock of how he thinks.
Well, probably true, but he I think we played a clip of him where he said that like on the statute providing attorney's fees, he said, well, they're smart enough they could put in attorney's fees to include cost if they don't wanted to. Well, the person who looks at it at different interpreting law based on purpose, which he referred to that as purposivism, they would say, well, the purpose was clearly to make the winning prevailing party whole. Well, that's what he just did in that statute. He said, well, the purpose, not in the statute, excuse me, in that amendment, he said, well, that was clearly the purpose and scope. But he's reading something into it that's not in the text. He's not truly being a textualist, but that doesn't I don't think make him a hypocrite. I think it makes him a mortal human being like the rest of us. We see things that help us in a particular situation. That's what we're for, and we're being textualist helps. I'm a textualist. When, like in the case of Nebraska with the registry, the argument that was that since Nebraskans convicted juveniles adjudicated in Nebraska didn't have to register, that clearly the intent of the legislature was that those coming in from out of state didn't have to register. Well, the Supreme Court of Nebraska said, nope, that's not what it didn't say that. It says you are a person, aren't you? You didn't move here, didn't you? You are required to register in Colorado, aren't you? Well, you're covered. That was a textualist interpretation. Well, I magically am not a textualist there. I'll all of a sudden go back to being purpose-driven, because clearly I think the purpose of Nebraska, no one ever thought about this when this law was being debated in 2009, which is the law we're talking about. No one raised that and saying, well, wait a minute. The language of this is going to clearly include, literally, it's going to include juveniles because it says any person, and person includes juveniles. And if you had raised that and said, well, ain't nobody going to ever, I mean, clearly we don't register juveniles here. No one would have taken that seriously, but they're taking it seriously now.
I understand your point.
So
well, let's shut this whole thing down. We have one more article to go and then we can get out of here. This is an article from The Appeal, so get ready to read for an hour. And it is, in one Arizona county, pay for your ankle monitor or go to jail. You talk about using ankle monitors as a diversion tactic to keep people that are pre-trial from, as a alternate way instead of you sitting behind bars, so you keep going to work, etc. Doesn't that fit into this model?
It does, but it doesn't. And that's like Ronald Reagan said when unemployment was skyrocketing. When Helen Thomas asked him, could unemployment go even higher? And he says, well, it could. Or it couldn't. It does. That's exactly what he said. Helen Thomas was the UPR correspondent, and when unemployment was skyrocketing in his first term, when it went to 7 or 8%, she says, could unemployment go higher? And Mr. President, he said it could. And then again, it couldn't. So this does, but it doesn't. Because if a person is facing long-term detention because they can't post a cash bond, and a GPS monitor would provide adequate monitoring. I mean, a jail is, we agree that monitoring doesn't get much more strict than in pretrial detention. You're monitored pretty much 24/7.
Unless your name is Jeffrey Epstein, in which you die, but that's a different conversation.
But here's the way the debate would fall out. You would have people like me saying, well, GPS would be appropriate because you wouldn't have to impose a cash bond. You could put the person out on GPS monitoring, and that would be enough tether that you'd be able to know that they're going to appear and that they would not be violating any of the conditions of not approaching the victim, and blah blah blah, not to go in alcohol establishments if they were accused of something where that was an issue. Those type of conditions, you'd say, well, that would be a great tool. But then the issue becomes who's going to pay for it. Well, we already know who's going to pay for the jail. That's going to come out of the jail budget that the taxpayers willingly pony up. But here's where it breaks down. Well, the person out there, the general taxpaying citizen, says, well, I don't think I want to pay for them to be out there roaming around the countryside on a GPS monitor. They can't. They ought to pay for that themselves. I already pay enough taxes. So you get into a situation where clearly GPS monitoring would be cheaper, less expensive, less costly than housing a person in pretrial detention. So in my model, I don't think that should be imposed on the person. I think that should be a societal cost to pay. But that's a tough one to sell to the general population because they already think they're being hit enough with taxes, just like the person who says, I don't want to pay for these people. I mean, whatever. I mean, they don't want to pay for it.
Wouldn't this actually potentially, quote unquote, reduce taxes?
Well, it would potentially reduce cost, but see, those costs never materialize, because if you take a jail that has 1,100 people in it, you let 50 of them go on GPS monitoring, there's not a reduction in the budget of the jail. You still have to have the jailers there manning the shifts. You still have to have the cooks there. You still have to run the facility. I mean, it still has to be air conditioned and ventilated. The cost of having 50 fewer inmates, I mean, you might save a few dollars on food. And of course, if one of them has a significant medical ailment, you might save a little bit on hospitalization, but it's not statistically measurable. But if you have to pay for 50 people to be monitored at $50 a day, that's a new line item in somebody's budget that has to come out from somewhere.
It sounds to me like the Larry Krasner approach was to end up shutting down some jails. That's what his approach was. That would save some money.
That would definitely save money if you actually close the facility. But just taking a few people out of the facility doesn't really translate to a dramatic reduction in the cost. We've learned that our juvenile system here barely has anybody in it, and it costs more to operate than ever before. And we don't have a soul in custody. I mean, we have the highest juvenile cost per inmate of the entire 50 states, because we have such a slender population, and we have these costs that have not commensurately dropped. And the conservatives were fond of pointing that out to us, because we told them, well, if you do juvenile justice reform, you're going to save all this money. And they said, well, hey, we hadn't saved any money. You're telling us the same song and dance now about doing justice reform on the adult side, and we ain't saved any money on the juvenile side. We've been at this gig for nearly 20 years now. So cutting the jail population without closing facilities, that's really the key to saving money. Is you got to close the facility, which runs into its whole set of problems, because what if the prison's still an substantial employer in that town?
Yes, absolutely.
All of a sudden,
that's where I was just going to go with that.
All of a sudden, you lay off 375 people.
Yes, and people are a little upset when that closes down.
Well, it's not only that, but it's the spending capacity goes down for those 375 people living in the town. The merchants start suffering, loss of economic activity, and people who hate government magically become big supporters of government then, because it's kind of like one year the governor was playing tough hardball in Capitol Outlay, which is the process by which we deal roads and bridges and community centers and things we spend money on, and the legislature. So it's a separate budget. The capital budget is a separate budget from the operating budget. And the governor was teaching us a lesson, and she vetoed the capital outlay, the entire capital outlay. And that affected the entire state. And all these people who were for fiscal responsibility all of a sudden started putting pressure on the governor, because all these capital outlay projects were not funded. And all of a sudden the bulldozers were stopping were going to have to be shut down. And all of a sudden people, towns that was livelihood depended on governmental spending, didn't have it. And good old Susie Q folded her tent, and she signed a capital outlay bill. But magically, people who hate government, when it comes to keeping their businesses alive, all of a sudden they love government for some reason. It sure is strange.
Interesting. I was going to throw in a question there, but let's get out of here, because we are incredibly way over time.
Well, I want to make a personal notice. One of the
please do.
A listener said that I was a little bit insensitive last week, and I tended to not think about it in the way that it was perceived about the people who think they're smarter than the police. And I didn't intend it the way it came across, and I apologize for that. What I intended to communicate is that when we break the law, whether it be a traffic law, whether it be speeding, whether it be not wearing our seatbelts, or whether it be traveling across the state to meet a minor or whatever, we all believe that we're not going to be caught. And it's not, so saying that you're smarter than the police is probably no doubt was a very poor choice of words. It's that we don't think it's going to happen to us. I mean, when you were driving home today, I don't know if you got a chance to do any speeding to get home, but when you decide to speed, do you speed with intent and the expectation you're going to get caught?
We shouldn't talk to me about that, because I absolutely 100% try to never speed because of the unintended consequences of perhaps killing people, or then I have to tell my PO I had an interaction with law enforcement, and I can't see how that's good for me when I have to talk to my handlers about that stuff.
But whatever we do, we do it with the expectation of not being apprehended. So when a person's on an online chat, they intuitively know that it could be a sting, but they believe that they've assessed the odds of their interaction, and they believe that in the conversation that it's all legit. And of course, they've been lied to by the person who's far more skilled at this because they are professionals and they're doing this for a living. But they end up, their analysis is that the odds are very low and they take the chance. But like I say, I apologize for that. I'm not intending on conveying to anybody that they're not smart. It's just that we don't plan to get caught when we do things.
Of course. Well, Larry, do you remember the website this week? Do you remember the website of where people can go to find the podcast?
I do not.
All right. It's registrymatters.co. And how about, can you remember the phone number? I'm sure you can.
I can always remember the phone number. So that is,
all right. Tell us what the phone number
is. That is 747-227-4477. And if we don't have a call next week, we're shutting this thing down. We're going to pull the plug on the telephone. We're going to quit paying $40 a month for a phone line that no one's using.
Man, that's harsh. All right. And then how can they email us?
Oh, that's easy too. registrymatterscast@gmail.com.
Outstanding. And then the best, ultimate, most awesomest way to support the podcast and show the love.
That'd be at patreon.com/Registry Matters. So if you go to patreon.com and you don't know Registry Matters, what would you do to try to find Registry Matters if you didn't know that extension?
Oh, there's a search box. Just type Registry Matters in the search box and we'll pop up.
So, all right. So go to patreon.com and just search for Registry Matters if you forgot the name of the podcast. If you've forgotten it already, I guess you couldn't be able to put it in the search bar if you've forgotten it.
It would be hard. If you've forgotten it already, then probably all hope is lost at this point.
Oh.
Well, Larry, as always, I super duper appreciate your time, your knowledge, your expertise, your fun banter, and your stories from your vast 200 and whatever years of life that you've got going on. And I will talk to you soon. Thank you so much.
Thank you. And I'm looking forward to the next century.
Absolutely. Perfect. Take care, guys. Good night.
You've been listening to FYP.